Hello, welcome. My name is Attorney Avery Druyon, and today I want to give a brief overview of what clients and what attorneys can expect when a family law case is being heard in tribal court. So before I get started, I wanted to explain the picture that I chose for this intro slide. So this is from this year's, so 2026 canoe journey. So this is the Nisqually tribe. Um, paddling currently. And what the canoe journey is, it's an annual cultural tradition where canoe families from different tribes throughout the Pacific Northwest, they travel through the ancestral waterways and they stop at different places and they're welcomed by other tribal communities along the way. So this year it's the well, pictured is the Nisqually tribe. But this image in particular is from their stop in and around the Tulalip tribes as they continue their way up north. So I chose that picture because as we're talking about tribes and tribal court, culture and tradition, it's not just background to the cases and the principles I'm going to be discussing. They're actually quite relevant, if not central, to how these family law issues and particularly parenting issues are decided in these courts. Um, so, with this basic overview, I'm going to describe a bit of, the procedures and how it works. It's more familiar than people might expect in terms of its similarities to the state court system they may be used to, but the important difference are that tribes are sovereign governments and they have their own laws, procedures, customs, priorities. And so the purpose of this presentation is to point out some of the differences that I've found as I've practiced in various tribal courts. So first, what do we mean exactly by tribal court? What is tribal court? So as I mentioned, tribes are sovereign governments. That means that they're not just, um, you know, tribal courts that are happen to be on state land or there's some kind of extension of state court. They are completely separate governments. They're considered the legal term is a government to government relationship is what's been defined in federal law. And that's still upheld, even though there's been some Supreme Court challenges regarding what encompasses the inherent sovereignty of tribes. That's kind of a whole nother rabbit hole that's very interesting, but for our purposes, know that, yeah, they are their own sovereign governments, and the states and the federal government are expected to, treat them on a government to government basis. In Washington state, we do have a pretty robust amount of tribes and diverse amount. There's currently 29 federally recognized tribes in Washington, and I think almost all of them have their own independent court systems. So, um, because again, they're their own sovereign government, they do typically fund their own tribal courts. If they have, tribal police, they're funding that themselves. They're funding, the judges that work there. Um, and they do have family law jurisdiction in their tribal courts. Um, yeah, they can govern themselves. They enact their own laws, which are typically called codes. They operate their own courts. And in terms of, what are they hearing? They're hearing divorces, parenting disputes, child support cases, protection orders, and other civil matters that are outlined in their codes, and along with some other things. And whether a particular case belongs in tribal court, that's going to be highly fact specific. Typically, it's going to depend on whether one party has tribal membership in that tribe, the party's connection to the tribe or the reservation land, and the subject matter of what they're dealing with. Right, does it deal with tribal members? Does it deal with property or other events that have occurred on the tribal land? And, the individual tribal code, of course, all of that plays into whether a tribal court is the proper place for the case to be heard. Um, so that said, procedurally, it may look surprisingly familiar to what people may be familiar with in state court. So some of the basic procedural similarities, you file a petition, you have to properly serve the other party, you submit evidence and motions, there's clerk's office to assist with that. You appear before a judge and you ultimately obtain orders. There are temporary order proceedings for determining issues on a temporary basis, and there are trials as well to determine final outcomes. So attorneys aren't necessarily relearning litigation from scratch. Bit of a side to this is that federally recognized Indian nations or tribes are required to essentially have follow a constitution that enshrines the same and very similar concepts to what the Constitution of the United States enshrines. That's how part of how they get federal recognition. And so that's why a lot of these procedural rights are the same or very similar to what you would find. But the biggest differences arise when you get into the substantive law, because, as I've mentioned, every tribe can enact their own unique code. So there is not one universal body of tribal law. It is distinct and different for each tribe, and every tribe has had a different method to come up with their body of laws. That's another interesting rabbit hole as well. Some tribes look to other tribes that have more developed laws, or even tribes that are not necessarily directly in the geographical area. A Washington tribe, for example, or a tribe located in the geographic area of Washington. They may look to other tribes on the West Coast. They may even look to tribes like in Oklahoma that have a more robust system, so they can kind of pick and choose. They may have a committee or a team of um, individuals in tribal government or otherwise that specifically write the code. It's typically ongoing. For example, in Tulalip, they're frequently revising and adding laws to the code as things arise. Just like a small, interesting tidbit is there are, fireworks are a big thing every year, especially around the Tulalip tribes. And because of that, there are a lot of firework type cases coming up through the tribal courts, whether that's like, violations. They have like a fireworks code, or if it's, criminal, um, etc. So one thing I've noticed is they've been really making their fireworks code more robust to specify what types of fireworks are illegal or not permitted. Um, Things like that. And they're updating their domestic relations codes, their domestic violence codes. So it's not something that's just set in stone. They are evolving and adapting as the with the tribe's needs. So every single tribe is different. And many of the basic concepts do resemble Washington law, but details can be meaningfully different in their application. So, do want to give a few examples here with domestic violence. So Tulalip and Stillaguamish, which are two tribes that I am barred in and have had plenty of litigation experience there. They have codes that expressly identify um, conduct that they consider to be covered under a protection order. So that includes terms like economic abuse and emotional or mental abuse. And they provide specific examples such as intimidation, controlling behavior, demeaning language, restricting access to services, destruction of property, harms or threats involving household pets. So, Washington law can address that type of conduct through the coercive control language that's in the state statute. But I find these codes particularly interesting because they expressly identify many of those behaviors. And because of that, I believe that um, it provides greater protection for victims or people in those scenarios when those behaviors are expressly defined in the code. Um, it gives more basis for somebody who is filing that petition and looking for that relief. And some parenting examples similar to domestic violence. And I guess I do want to add this before I move on to the next example. Um, it's extremely important to understand the historical context behind why some of the domestic violence or parenting laws may be more expansive or provide possibly more relief. Um, Many tribes have a much higher rate of domestic violence. Um, Many people have heard as well of missing and murdered Indigenous women. The statistics show that I believe that Native women are the top, if not in the very top, um, in terms of the most domestic violence committed against them, the most, um, like murdered or missing population. So, and a lot of that again is a history of colonization, right? Their lands and their homes being colonized by um outsiders coming in and forcing um their laws, their life onto the tribe. And so there is quite a history there, and violence, I'm going to say outright. So it makes sense that the tribes have a particularly vested interest in making sure that their tribal members have relief in their own tribal courts against these kinds of behaviors. So with that being said, some parenting stuff. Some of these tribal codes also provide, I would say, significant protections when there has been DV, neglect, or abandonment. I think abandonment, particularly with tribes, is where I'm seeing a much stronger presumption that, you know, the tribes might even permit, the code might permit that one parent has extremely limited, if not even completely restricted rights to the child if they have abandoned the child. Um, it depends on the tribal code what abandonment means. Sometimes it's as little as a year where you've had no contact. Whereas I think in Washington state courts, typically this state is going to give one parent at least some rights, no matter kind of how much abuse or neglect or abandonment there's been. I think domestic violence is taken um, rather seriously in the state courts, considering how broad the law is there. But I would say with abandonment, I'm not sure from my experience and what I've noticed practicing in both. That's typically not as strong of a basis to, fully restrict time. Usually, like the parent can abandon, but if they come back and they show they want the parenting time, typically they are going to get some. So there's a big difference there. And again, I think there are plenty of historical foundations for, um, right, these kind of historical family issues in the tribe that they're trying to address, and with abandonment and trying to, have an interest to um, protect the stability of the child and protect the stability of the tribe. So, on that note, I think certain findings in the Tulalip Code can also create much stronger presumptions that favor limiting on parenting time, including like domestic violence. For example, the code, if there is like a finding of domestic violence or there is a protection order entered against that parent, there is already a presumption that they will have limitations or restrictions unless they demonstrate a certain level of treatment or rehabilitation to overcome those limitations. I've seen that happen in Washington state courts, of course. There are what we call, 191 limitations on a parent's time. But to me, it seems the burden is almost not flipped, but if there's a protection order in state court, for example, that may very well create the presumption for the 191. In other times, I've seen maybe a little bit more proof might be needed to establish the 191, or if there wasn't a protection order, you may need to, um, it's the burden is on you really to prove that there should be the limitations. Whereas, um, just from my practice and how I've seen it applied, there's a bit stronger of a presumption automatically made in Tulalip where the other person is having to automatically overcome that. So it's a bit nuanced there, but I think it's an important difference. Um, so I think that's why you can't just walk into tribal court and assume that the Washington analysis applies, um, because there are differences in the law, and Washington law has no authority there. The order of authority is going to be, tribal case law, and then federal, and then state. So I know that that was a bit lengthy, but I think it's an interesting conversation. So, biggest point I want to make is that tribal custom matters. So culture is a part of the legal analysis. And I think it's the most interesting and where you can really make the most creative and powerful arguments for your tribal court client. I want to say many, if not all, tribal codes that I've seen expressly direct the courts to consider the tribe's customs, traditions, and cultural practices when interpreting and applying the laws. And this can become especially important in parenting cases because maintaining the child's connection to their tribal identity and community may be relevant to the child's best interests, and um, I would say especially determinative in cases where one parent is a tribal member and the other parent is not. How are we going to make sure that the child is maintaining their tribal and cultural connection when they're with the non-tribal parent? Is that parent going to encourage, the relationship to the tribe? Are they going to take them to events, etc.? So I've seen parenting arrangements. many parenting arrangements, it's expressly in the parenting plan that there needs to be participation in and cooperation with powwows, canoe events, and other tribal cultural activities. Um, I guess to just pause here, the picture that I've included, this is from Tulalip Day at, I believe this is Quilceda Elementary School. So Tulalip Day is actually an established holiday in the Tulalip tribe, and it is the last Friday every November, and it's to really celebrate the traditions and sovereignty of the tribe, and especially with the historical context of Tulalip boarding school. And again, that's kind of a whole nother rabbit hole of tribal history with boarding schools and genocide and violence that was done there, sending children to those schools to try to have them conform with white and Western culture, I suppose. So, anyways, it's also an event at the elementary schools where, they get to um, perform their cultural customs and traditions. So, super cool. So, a key point here with the parenting is again just determining which parent is going to be more likely to maintain the child's connection to not just, the culture at large, but their family and their community, right? Is dad, non-tribal dad gonna um encourage, relationships with grandma, aunties, cousins, because that can be especially intertwined and interwoven in Tulalip, but not take them away from those people. Um, and I mean, there can even be examples. I had a case where I represented the non-tribal member, mom and father is a tribal member, but he had abandoned them completely. And so mom was actually the parent who was encouraging more of fostering the connection with the tribe and the traditions. And so it can be an extremely important parenting consideration. And that's something that I think an attorney could easily overlook if they're only looking at cases through like a Washington lens. Um, Sorry, I think I may be missing a slide, but we can just kind of use this slide. Um, well, actually, this works. Um, just wanted to touch on how property division can be different too, because I know I've spoken a lot about parenting and domestic violence concepts. So, from my experience, a lot of the tribes do have similar property principles to Washington. They are using community property law, but tribal specific property and funds can require a different analysis and again be extremely outcome determinative of a case. So, tribal trust land may not be divisible in a divorce, and that is, again, depending on the tribe, many tribal members own land that is held in trust by the tribe. Again, that's a whole nother rabbit hole, but it's something to keep in mind with property division. There's also tribal housing can present some unique ownership or occupancy issues. For example, the Tulalip tribe offers housing for its members, and some of the housing is for rent to the tribe, but other times they will offer the housing for sale so that the tribal member owns the piece of property. And there can be some very unique considerations um, when dealing with that situation in terms of property ownership, who's funding it, because, sometimes it depends on the tribe. They may have resources available, for the down payment of the home and things like that. And so it's really important to understand the context to be able to help sort things out and possibly make arguments um, about how to treat the property. Um, Again, so there's tribal distributions, stipends, and other benefits. So what I've seen between like the Tulalip tribes and the Stillaguamish tribes, so Tulalip, for example, has like a stipend, I guess you would say, for the child. It's for the child's interest and um, as they grow up. And it can either go directly to a parent and it's supposed to be for, their welfare, or it can go into a trust account that is held by the tribe and then available for the child once they turn 18. So that issue has definitely come up because that can be a part of like a child support order. Where, which parent gets the tribal funds? Are we going to keep it in the trust account? Etc. Another one is, tribal members may receive benefits directly. In Stillaguamish Tribal Court, members do receive, if you are, a tribal membership and improve that, um, just like a base, I would say stipend amount. Tribal elders, so if they reach a certain age, also receive um, elder benefits. It's almost like the tribe's own social security program. And then they also have health and welfare funds where members can apply. That can even be for a down payment of a house. It can be for improvements to a house. It can be for school funds. It can be for a variety of things. And then the tribe distributes those funds to you. So it's really important to know how those work. And so, that's where you can make strong and creative arguments for your client. If you represent the tribal client, I've certainly made arguments that certain funds should be the separate property of my client. I don't want to get too much into that, but I think that's where some of my biggest like successes in tribal courts. I've had a tribal court rule after trial that the home that they paid for with their tribal funds um, is their separate property completely because it was paid for with the tribal funds. I had that in another case as well. So again, that's not a part of their actual code, but it's something where there's some ambiguity that you can argue that. Um, and then even just aside from whether property is divisible or not, typically I would say if you're receiving like a tribal stipend from the tribe, it may constitute income for child support or spousal support purposes. So it's critical really to understand exactly what the tribal asset or benefit is before assuming that ordinary Washington property law applies. So let's see where we're at. Almost to the end here, wanted to highlight um, something that I think is really cool. It's called Yeehaw, and this is one of my favorite examples of how a tribal court can create their own process that's specifically suited to their community. So Tulalip uses Yeehaw as a family law dispute resolution process. This comes from um, a word from a tribal language. I don't think it's from a Tulalip tribal language, and need to, yeah, verify me on this, but I believe the meaning is something like, to create a path forward, to create resolution. Um, and it's a family law dispute resolution process, and the best way I can describe it is essentially like a mediation and maybe an arbitration combined, or like a mediation done by the judge of the court, and they can make a decision at the end of the day, but it's also kind of a therapeutic, and the judge will start off with just not asking for a history, but like what's the current and what how can we get forward, right? Let's leave the past behind us and how can we just move forward today with a resolution? I would say it's not as cut and dry as other mediations where, it's like, feelings off the table. Background is kind of off the table, right? And it's a shuttle mediation. So it's just very, let's get this done, which I think has its place. But this is a very unique way to just have a face-to-face interaction with it's typically one judge at Tulalip, Peter Boom, who I believe is writing a book on his dispute resolution philosophy. So, yeah, the parties have an opportunity to speak a bit more directly about the history of their conflict and what needs to happen. In my experiences, it's been much less evidence-based. It's a lot more talking between the parties, and I'm just I'm there to just remember all of the legal things that need to go into like a parenting plan and to draft that as I'm there. But it's really about the parties and about the judge that is coordinating this. So it's a much more direct role, and I would say in state courts that is not something that an active judge would be doing. Um, but yeah, it's kind of a counseling or a healing aspect to it. And I'm seeing them like increasingly order yeehaw in family law cases as opposed to going to trial. Um, and instead of moving like every unresolved dispute to trial, it's let's send them to yeehaw first. Unless there's like domestic violence, then they have the option, of course, not to do that. But I think it reflects a different philosophy, an innovative philosophy. And it's not just about winners and losers, but trying to help the family move forward. So why does tribal court experience matter? The biggest thing I want as a takeaway is that tribal court is not monolithic. Every single one is different. You can't generalize. Um, every single tribal court. I've tried to pull out principles today that I'm seeing applied, but know that every time you step into a tribal court, there's a very unique community there, members, a unique history, and to be respectful about that. While there are a lot of similarities to the procedure, there's also a lot of nuanced differences in their code and in their customs. So, an attorney in tribal court would need to determine first which court has jurisdiction. Is it tribal court? Is it state court? Um, what that particular code says. What tribal custom affects the issues at hand. Whether tribal property or benefits require any special treatment or investigation. And whether that court offers a unique resolution process. Don't just take a Washington state argument and transplant it into tribal court. That would be a mistake. So, as I had mentioned before, I am admitted to practice in the Tulalip and Stillaguamish tribal courts. I've also practiced in the Swinomish tribal court, and these are the differences that I've had the opportunity to see firsthand in family law practice. And it's really been an honor to practice there and to learn there. So, any questions for anyone? If there's anyone that is interested in practicing in tribal courts has a case that is potentially in tribal court. If you are a tribal member that's wondering about their case in tribal court, or a non-tribal member that's wondering how this all works, feel free to send me an email or to call our firm at Beresford Booth. Um, Happy to represent you in a tribal court case or to chat more. Thanks so much for staying tuned.